I want you to close your eyes for a second. Well, unless you're driving. If you're driving, please keep them open.
Right. Safety first.
But imagine this scenario. It's, I don't know, 11:30 p.m. You're coming back from a friend's house. The road is empty. You're relaxed. Maybe you're singing along to the radio. And then, seemingly out of nowhere, the interior of your car just lights up. Blue and red.
Yeah.
Flashing.
It is the universal signal for your night just got complicated.
Exactly. Your stomach drops through the floor, your pulse hits 120, your hands get all sweaty on the wheel.
It's a completely visceral biological reaction.
Yeah, it really is. And in that moment of just pure panic, a million questions fire off in your brain. What did I do? Do I have to answer their questions?
Can I just drive to a well-lit area? Do I have to get out of the car?
Yeah.
All of it.
And that panic is exactly where people get into trouble. Not because they are hardened criminals, but because that fight or flight response just kicks in and they make a split-second decision that turns a speeding ticket into a felony.
That is the nightmare scenario.
That is the nightmare scenario we are tackling today. We aren't talking about murder or grand larceny. We're talking about the crimes of interaction. We are taking a deep dive into a stack of paper that defines the rules of engagement between you and the government. We are unpacking Texas Penal Code Chapter 38.
Officially titled Obstructing Governmental Operation.
Which sounds like the driest, most bureaucratic thing you could possibly imagine. It sounds like a form you forgot to file in triplicate.
It does sound like paperwork, but I promise you, this chapter is, well, it's the operating manual for a cage fight.
A cage fight.
It defines the razor-thin line between exercising your civil rights and committing a crime against the state. It covers everything from what you must say to a police officer to legalities of flying a drone near a prison, even the shady world of ambulance chasing.
So our job today is to translate all that dense legalese into plain English so you can actually understand it, retain it, and hopefully, never have to use it. But before we dive into the nitty-gritty of the law, I do need to ask you, the listener, to do something for us right now. It takes 1 second.
It really does help.
Just hit that subscribe button. It helps the channel grow, it helps us keep the lights on and the research flowing, and it makes sure you don't miss out on this kind of crucial info.
And check out our website. We have more resources and breakdowns of what we're about to discuss.
Okay, business over. Let's get to the law.
Let's do it.
So, Chapter 38. Why start here? Why does this specific chapter matter to the average person who isn't, planning a heist?
Because Chapter 38 is the catch-all for interactions with authority. Most people think the Penal Code is a list of bad acts. Don't kill, don't steal, don't burn things down.
The big stuff.
Right. But Chapter 38 is about the process of justice. It's about how you interact with the government when it's trying to do its job.
So it's meta law. It's laws about enforcing the other laws.
Precisely. And here's the kicker. You can be completely innocent of the original crime. You could be stopped for a robbery you didn't commit. But if you handle that interaction wrong, if you resist, if you lie, if you run, you can talk or act your way into handcuffs for violating Chapter 38. You could beat the robbery charge and still go to jail for the obstruction.
Wow, that is the scary part. You can be innocent of the act, but guilty of the reaction.
That is the perfect way to put it.
Okay, let's unpack this. We've got a lot of ground to cover. Let's start with segment 1, the initial encounter. This is the big one. Identity and resistance. I feel like there is this massive myth out there, thanks to TV and movies, that if a cop asks you for your ID, you always have to hand it over. Like, papers, please? True or false?
That is a very complex false. It is one of the most misunderstood areas of law, and, getting it wrong leads to so many unnecessary arrests.
Okay, so break it down for us.
To understand Section 38.02, failure to identify, we have to distinguish between two legal states of being. You need to know if you are detained or if you are arrested.
Okay, let's drill down on this because I think most people, myself included, use those words interchangeably. What is the actual difference?
A detention is temporary. The officer has what's called reasonable suspicion that something is up, so they stop you to investigate.
So you're not free to leave.
You are not free to leave, but you aren't in cuffs yet. An arrest is, well, it's more permanent. They have probable cause to believe a crime was committed, and they are taking you into custody.
Got it. So, scenario A. I'm walking down the street, minding my own business. An officer stops me and says, "Hey, hold on a second. You look like a guy we're looking for. What's your name? Let me see some ID."
Okay.
I'm detained, right? I can't just walk away.
Correct, you are detained, but And this is the crucial part. Under Texas Penal Code 38.02a, you are not required to identify yourself.
Really? I could just stand there and stare at him.
You can stand there mute. The statute says a person commits an offense only if they intentionally refuse to give their name, residence address, or date of birth to a peace officer who has lawfully arrested the person and requested the information.
So if I'm just detained on the sidewalk,
Right.
I can keep my wallet in my pocket.
Yes. In that specific scenario, silence is not a crime. Refusal is not a crime.
Okay, but let's flip the script. Scenario B. I'm driving. I'm in my car. Same situation. Officer lights me up, pulls me over. License and registration. Can I refuse then?
Absolutely not. This is where the license privilege doctrine comes in.
Uh-huh.
Section 38.02, subsection B1, changes the game completely.
How so?
If you are the operator of a motor vehicle and you are lawfully detained, not arrested, just detained for a traffic stop, you absolutely must display your driver's license.
So the car itself strips away that right to anonymity.
Exactly. When you get a driver's license, you are entering into a contract with the state.
Mhm.
You're agreeing that if you operate this, 2-ton piece of machinery on public roads, you will identify yourself when asked by law enforcement.
So, walking and detained, you can stay quiet. Driving and detained, you must show the license.
That is the distinction.
That is a huge distinction. Okay. Now, what if I panic?
Yeah.
What if I'm detained on the street? I know I don't have to give my name, but the officer's intimidating me. So I just decide to make something up. My name is John Smith.
You just stepped into a bear trap.
How so?
Because while you have the right to remain silent, you do not have the right to lie. Subsection B of the statute is very, very clear. It is a crime to intentionally give a false or fictitious name, address, or date of birth.
And that applies if you're just detained.
It applies if you are arrested or if you are lawfully detained.
Whoa. So I can stay silent if I'm just detained and not driving.
Right.
But if I choose to speak and I lie, that's a crime.
Yes. It's the cover-up that gets you. Silence is a shield. Lying is a sword, and the law punishes you for swinging it.
Okay.
And there is one more kicker here in the statute that catches people off guard. You also cannot lie if the officer has good cause to believe you are a witness to a criminal offense.
Explain that. What does that mean?
Let's say you aren't the suspect at all. You're just a bystander. You saw a bank robbery happen across the street. The police run up to you and say, "Did you see that? What's your name?" If you give a fake name because you don't want to get involved, you have just committed a Class B misdemeanor.
So even witnesses have a legal obligation to be truthful about their identity if asked.
Correct. The state argues that it needs accurate information to investigate crimes. If you pollute the investigation with fake names, you are obstructing governmental operation.
It seems like the penalties escalate based on who you are, too.
They do. Generally, failure to ID is a Class C or Class B misdemeanor. It's a nuisance charge, really.
Okay.
But if you are a fugitive from justice, meaning you have a valid warrant out for your arrest, and you refuse to ID yourself or you lie, the charge gets upgraded. A Class B becomes a Class A misdemeanor.
So if you have a warrant, the law punishes you more for trying to hide it.
Exactly. They are stacking the deck against evasion.
All right, moving from talking to acting. Let's talk about the physical side of things.
Yeah.
Section 38.03, resisting arrest or search. I think we have all seen videos on the internet of people wrestling with police officers screaming, "I didn't do anything," or "This is an illegal arrest." Let's look at the text. What actually counts as resisting?
The definition in 38.03a is pretty specific. It's intentionally preventing or obstructing a person you know is a peace officer from effecting an arrest, search, or transportation.
Mm-hmm.
But here's the key phrase that lawyers argue over constantly.
What's that?
By using force against the peace officer or another.
Using force. That seems subjective. If I just go limp, passive resistance, is that force?
Generally, no. Going limp or dead weighting usually isn't charged as resisting arrest under Section 38.03 because it lacks active force directed against the officer.
Okay.
It might be interference, which we'll get to, but resisting usually implies pulling away, pushing, striking, or actively fighting back.
Okay, here's where it gets really interesting for me and honestly kind of terrifying. What if the cop is wrong? I mean, completely factually wrong. They think I'm the guy who robbed the store, but I've been at my grandma's house all day. They grab me. Can I pull away? Can I fight back to protect my liberty?
No, absolutely not. And I need the listeners to really, really hear this part because it goes against every instinct you have. Section 38.03b states explicitly, "It is no defense to prosecution under this section that the arrest or search was unlawful."
Wait. I need you to read that again. It is no defense that the arrest was unlawful.
That is correct. You could be 100% innocent. The officer could be making a massive mistake. The arrest could be technically illegal. Maybe they don't have probable cause. Maybe they have the wrong house.
But I can't fight it.
You are not allowed to use force to resist it in the moment.
That feels incredibly unjust. Why would the law demand I submit to an illegal act?
It's a public policy decision, really. The state has a monopoly on violence. They do not want street corners turning into brawls over legal interpretations.
So the logic is...
The logic is, comply now, litigate later. They want you to fight the arrest in a courtroom with a lawyer, not on the pavement with your fists. If you fight an unlawful arrest, you might beat the original charge because it was bogus, but you will still be convicted of resisting arrest.
That is a hard pill to swallow. You have to submit to an injustice in the moment to avoid becoming a criminal yourself.
It is, and the stakes are high. Resisting is a Class A misdemeanor. But if you use a deadly weapon to resist, it becomes a third-degree felony.
So the takeaway is, fight it in court, not on the street, even if you're right.
Especially if you're right. Don't ruin your perfect defense by adding an assault charge on top of it.
Let's talk about the next step up from that. Resisting is fighting back. Section 38.04 is evading arrest. This is running away.
Right, evading arrest or detention. The core element here is intentionally fleeing from a person you know is a peace officer attempting to lawfully arrest or detain you.
Fleeing, does that mean sprinting? Or?
It covers everything: running, driving, swimming. The statute explicitly mentions vehicles and watercraft.
I noticed there's a massive jump in penalties depending on how you flee.
Huge. And this is another trap for the uninitiated. If you run on foot, you just bolt, and it's your first time. It's a Class A misdemeanor. Serious, but not, life-ending.
Right.
But the second you get into a car operating a motor vehicle to flee, it immediately becomes a felony. A state jail felony at minimum, or a third-degree felony if you have done it before.
Just by being in a car. Why the harsh jump?
Think about the danger to the public. A guy running through a backyard might twist an ankle. A guy fleeing in a 4,000-pound vehicle at 90 miles per hour turns the public road into a weapon.
It's about collateral damage.
Exactly. The law punishes the potential for collateral damage.
Now, I was reading through this section 38.04, and I found something incredibly specific and honestly kind of wild. Subsection B2C. It talks about tire deflation devices.
Oh, yeah. The legislature really wanted to cover all their bases here.
It says if the actor uses a tire deflation device against the officer while fleeing, the penalty jumps. Are we talking about caltrops? Like in a James Bond movie?
Essentially, yes. The code defines a tire deflation device by referencing another section, but yeah, it usually means caltrops, spikes, or nails specifically designed to puncture tires.
So if I'm leading the cops on a chase and I press a button and drop spikes out the back to take out the cruiser?
You are looking at a third-degree felony. If someone gets hurt because of those spikes, it can go up to a second-degree felony.
That is oddly specific. But I guess if you're prepared enough to have caltrops installed in your Honda Civic, the law is prepared to throw the book at you.
It just shows that the law evolves to meet the methods criminals use. Someone somewhere did this, and the legislature said, okay, we need a specific law for that.
Okay, so that's the initial encounter. Identity, resisting, fleeing, don't lie, don't fight, don't run, and for the love of God, don't drop spikes. But what if you aren't the one in trouble? What if you're just the loyal friend? That brings us to segment 2, accessories and interferences, helping the bad guys.
This is where a friendship can get you a criminal record. Section 38.05, hindering apprehension or prosecution. This is essentially being an accessory after the fact.
What specific actions cross the line here? Because I think most people would instinctively want to help a friend or a family member.
The code lists 3 main ways you can break this law if your intent is to hinder someone's arrest. First, harboring or concealing them.
Hiding them in your basement when you know the cops are looking for them.
Right. Second, providing means to escape, giving them money, a car, or a weapon.
And the third one?
Warning them of impending discovery or apprehension.
Warning them. So let's play this out. My buddy has a warrant. I see a police car turn onto his street. I text him, hey, cops are coming, get out.
If you do that with the intent to help him avoid arrest, yes, that is a crime. It's usually a Class A misdemeanor. You're actively working against the state's effort to apprehend a fugitive.
That feels like a very natural human impulse, though, to protect your own.
It is, but the law demands you prioritize the justice system over personal loyalty. However, and this is fascinating nuance, there is a defense built right into the text.
Oh, really? Is this the Good Samaritan defense I've heard about?
It's subsection B. It's a defense to prosecution if the warning was given in connection with an effort to bring another into compliance with the law.
Oh, that's clever. So the framing matters a lot.
Context is everything. If you text him, hey, the cops are outside, run, that's a crime.
Right.
But if you text him, hey, the cops are outside, you need to go out there and turn yourself in before this gets worse, don't make them kick down the door, that is likely a defense.
Because your intent wasn't to hinder the arrest, it was to facilitate a peaceful surrender.
Exactly. You are helping the process, not hindering it.
Now, moving on to Section 38.15, interference with public duties. We usually think of this as obstructing a police officer, but the list of protected workers is actually much, much longer.
It is surprisingly broad. It includes peace officers, obviously, but also EMTs, firefighters, animal control officers.
Health inspectors.
Even people enforcing health and safety codes, yeah, like health inspectors.
So if a health inspector tries to enter a restaurant kitchen to check for rats, and the owner physically blocks the door.
That's interference with public duties. Section 38.15a defines it as interrupting, disrupting, impeding, or interfering with criminal negligence.
But, and this is a big but, we live in a country with free speech. The First Amendment exists. Can I stand there and tell the health inspector he's doing a terrible job? Can I film the police and yell at them while they work?
That is the crucial constitutional cutout. Subsection D states, it is a defense to prosecution that the interruption, disruption, impediment, or interference alleged consisted of speech only.
Speech only. Let's unpack that phrase.
It means you can scream, you can argue, you can, interpret the Constitution at the top of your lungs, you can call them names, as long as your body acts as a ghost, meaning you are not physically touching them or blocking their path, you are generally protected.
So the line is physical obstruction.
Right. If you stand in front of the EMTs so they can't get the stretcher to the patient, that's physical interference. That's a crime.
But if I'm 10 feet away...
If you stand 10 feet away yelling that they are incompetent, that is speech. It might be rude, but it's legal.
That distinction is vital. You can be annoying, you just can't be an obstacle.
Correct. But be careful. There is a modern addition to this section regarding doxing that complicates the speech defense.
Right. Putting people's private info online. Subsection D1.
Exactly. We live in the age of viral videos. But the legislature added a provision that says there is a rebuttable presumption that you are interfering if you disseminate a peace officer's home address, phone number, or social security number, or their family's info with the intent to harm or interfere.
So speech doesn't protect you if you are weaponizing private information.
Right. If you film an arrest, that's generally fine. But if you dig up the officer's home address and tweet it out saying, this is where he sleeps, go get him, you've crossed the line from free speech to interference and probably other crimes too.
It's interfering with their ability to do their job by threatening their safety at home.
Exactly. It adapts the law to the digital age.
Before we leave this segment, there's one more tech-related interference. Section 38.152.
Interference with radio frequencies. This is for the people who get their hands on powerful radio equipment and decide to jam or interrupt emergency bands, police, fire, EMS.
Is that actually a thing? People jamming police radios?
It happens. Sometimes it's pranksters, sometimes it's criminals trying to block communication during a heist. But the law takes it very seriously.
I can imagine.
If you intentionally jam a police frequency, it's a Class A misdemeanor. If you do it to help someone commit a crime or stop EMS from responding to an emergency, it becomes a state jail felony.
Don't mess with the radios. Got it. Okay, segment 3, don't touch that. This covers weapons and animals. Section 38.14 seems pretty straightforward. Taking a weapon from an officer.
Straightforward, but the penalties are severe. This statute covers attempting to take a firearm, nightstick, stun gun, or chemical dispensing device, which is pepper spray.
Attempting to take, so you don't even have to succeed.
No. If you try to grab it and miss, or if the officer overpowers you, you've still crossed the line. If you successfully take their gun, it's a third-degree felony.
And if you just try.
If you just attempt to take it, it's a state jail felony.
And I assume, I didn't know he was a cop. Doesn't fly if they're in uniform.
Right. The law presumes you know they're an officer if they're wearing a distinctive uniform or badge.
What about the defense here? Is there ever time you can legally grab a cop's weapon?
Subsection D offers a defense if the officer was, quote, using force against the defendant or another in excess of the amount of force permitted by law.
So, self-defense against police brutality.
Basically, if an officer is using excessive illegal force, say, they are beating a handcuffed suspect with a baton. and you grab the baton to stop the assault, you can argue this defense. But you have to realize, proving excessive force in court is a very, very high bar.
You're taking a massive risk.
A massive risk in that moment.
Let's talk about the four-legged officers. Section 38.151, interference with police service animals. We're talking canines and horses.
This section protects the animals just as strictly as the officers in some ways. It covers dogs and horses used for law enforcement, corrections, or investigations.
What counts as interference here? I saw a taunting on the list, which seems kind of minor.
It ranges from taunting to killing. If you recklessly taunt or torment a police dog, barking at it, trying to rile it up, it's a Class C misdemeanor. But if you throw something at it, it bumps up to Class B.
What about the area of control? I saw that phrase and it sounded like a force field.
That is interesting. You commit an offense if you enter the animal's area of control without consent. That includes a vehicle, kennel, or a fenced area.
So let's say a canine unit is parked at a gas station. The dog is barking in the back seat. I walk up and open the car door.
You just committed a crime, even if you didn't touch the dog. You breached its containment. The law views the car as the dog's workspace.
And if you actually injure the animal?
It escalates rapidly. Injuring or killing a police service animal is a felony. It's a second-degree felony if you kill it or maim it permanently.
A second-degree felony.
The law treats these animals not as pets, but as vital equipment and as fellow officers. Killing a police dog carries significant prison time.
So the rule is, don't pet the working dog, don't tease the working dog, and definitely don't let it out of the car.
Exactly. Just give them a wide berth.
Okay, let's go behind bars for segment 4, the prison ecosystem. We're talking about escape and contraband. Escape seems obvious, section 38.06, but there's a distinction between escape and permitting escape.
Right. Section 38.06 is the prisoner breaking out, unauthorized departure from custody. If you just run away from a work detail, it's a Class A misdemeanor. But if you're a felon when you run, it's a third-degree felony.
And if you hurt someone?
If you cause bodily injury or use a weapon to break out, it can go all the way up to a first-degree felony. That's life sentence territory.
And permitting escape in section 38.07.
That's for the guards or the employees. If an official knowingly permits or facilitates an escape, maybe they accidentally leave a gate unlocked because they were bribed, they are committing a crime. It holds the keepers accountable.
Now let's look at what goes into the prison. Contraband. Sections 38.11 on and 38.114. We know you can't bring in drugs or guns. That's a given. But looking at the list, there are some specific items that carry huge penalties that might surprise people.
The forbidden list includes alcohol, controlled substances, deadly weapons, money, and tobacco in certain facilities. But the one that gets people caught most often these days, and carries a shocking penalty, is in Section 38.11A3.
Cellular telephones.
A cell phone, just a regular iPhone.
A cell phone, a SIM card, a battery charger, any component. Providing a cell phone to an inmate is a third-degree felony. Wow. Wait, let's just pause there. A felony. That's the same category as some assaults. Why is a phone treated like a weapon?
Because in prison, information is power. A phone allows a gang leader to order hits on the outside. It allows them to organize riots. It lets them continue running their criminal empire from their cell.
So it's a security breach.
The state views a cell phone in prison as a massive security breach, almost on par with a gun. It breaks the isolation that prison is supposed to enforce.
And I read something about strict liability regarding property. This felt like a trap for regular people visiting loved ones.
It is a massive trap. Subsection C of 38.011 says you commit an offense if you take drugs or contraband onto property owned, used, or controlled by a correctional facility.
So property includes the parking lot.
Yes. Imagine you're a mom visiting your son in prison. You drive your car into the prison parking lot. You have a bottle of wine in the trunk from a dinner party last night, or maybe a prescription bottle that isn't in your name.
Okay.
You park, you walk inside. You never even take the items out of the car.
But they're on the property.
Correct. If they search your car, you have just committed a felony. You brought prohibited substances onto correctional property.
That is a terrifying technicality.
It is. The advice here is just
Yeah.
clear your car completely before you even turn onto the prison road. Don't become a felon by accident.
Technology keeps advancing, and so does the code. Section 38.115 covers drones.
Operation of unmanned aircraft over correctional facility. This is a direct response to the modern era. People were using drones to fly over prison walls and drop packages, drugs, phones, cigarettes into the yard.
So the legislature just banned the airspace.
Yes. You cannot fly lower than 400 feet above a correctional facility. You can't let the drone make contact or drop anything.
400 feet. That's the FAA limit for hobbyist drones anyway, right?
Generally, yes. So essentially, you cannot fly it all over a prison. It's usually a Class B misdemeanor, but if you use the drone to deliver contraband, it becomes a state jail felony.
One last thing in the prison segment, Section 38.111, improper contact with victim. This seems like a protection for the people outside.
It is. This prohibits inmates from contacting their victims. If you are in for domestic violence or a sex offense, you cannot write, call, or message the victim unless the director of the facility has received written consent from the victim.
That protects the victims from harassment from behind bars.
Exactly. It removes the captive audience fear for the victim. You shouldn't have to receive letters from the person who hurt you.
All right, let's switch gears completely. We're leaving the streets and the prisons, and we're going to the office. Segment 5, Professional Misconduct and Scams. We are talking about barratry, Section 38.12.
Barratry. It sounds like something from a pirate ship, doesn't it?
It really does. The charge is barratry. But what does it actually mean in modern Texas?
It is the legal term for ambulance chasing. It's soliciting employment, specifically legal or professional employment, to obtain an economic benefit.
Dummy it down. Give me the scenario.
It's when a lawyer, or more likely a runner working for a lawyer, approaches a victim of an accident who hasn't asked for help and tries to sign them up as a client.
So, hey, I heard about your crash. I can get you $1 million, sign here.
That's it. We've all seen the billboards, the TV ads with the hammers and the screaming lawyers. Is that barratry?
That's not barratry.
No, general advertising is legal. Barratry is about direct, unsolicited contact. Getting in someone's face, sending them a DM, calling their cell phone.
Okay.
And there is a very specific rule in subsection D2A that I think is fascinating. The 31-day rule.
What is the 31-day rule?
Professionals, attorneys, chiropractors, private investigators cannot contact an accident victim or their family with a solicitation for at least 31 days after the accident or disaster.
Why 31 days? That seems so arbitrary.
It's a cooling off period. Think about the humanity of it. Imagine you are in a terrible car wreck. Maybe a family member died. You're in the hospital. You're grieving. You're in shock.
Right.
You don't want your phone ringing off the hook with lawyers trying to make a quick buck off your tragedy.
It prevents them from preying on vulnerability.
Exactly. It gives people space to grieve and heal before they have to think about lawsuits. If a lawyer calls you on day 2, they are committing a crime.
Does it apply to everyone?
It applies to professionals. The code lists attorneys, chiropractors, physicians, surgeons, and private investigators. Basically, anyone who stands to profit from your injury.
And then we have the fakers. Section 38.122 covers falsely holding oneself out as a lawyer.
This is the catch me if you can section. If you pretend to be a lawyer to make money but you aren't licensed, it's a third-degree felony.
In Section 38.123, unauthorized practice of law.
That catches the non-lawyers who try to negotiate settlements. Say you're an insurance adjuster or just a fixer and you tell family, don't get a lawyer. I can handle this personal injury claim for you for a fee. If you aren't a lawyer, you are breaking the law.
Leave the lawyering to the lawyers.
It sounds self-serving for the profession, but bad legal advice can ruin someone's life. The state has an interest in ensuring only qualified people give it.
We have covered a lot of don'ts. Don't resist, don't smuggle, don't scam. But the law also has a list of musts. This is a real shift in philosophy.
It is.
Segment 6, the duty to speak.
This is the ethical core of Chapter 38. Most of the time, American law doesn't require you to be a hero. You can generally watch a bank robbery and just walk away. But there are specific situations where silence is a crime, where looking the other way makes you guilty.
Let's start with the most critical one. Section 38.17, failure to stop or report sexual or assaultive offense against a child.
This is non-negotiable. If you observe the commission of a sexual or assaultive offense against a child, you must either assist the child or immediately report to law enforcement.
I feel like that is a moral duty regardless of what the law says.
It is, but the law codifies it. It says we will not tolerate the bystander effect when children are being hurt.
Are there exceptions? I mean, what if the attacker has a gun?
The law isn't a suicide pact. You're required to act only if you can do so without placing the actor in danger of suffering serious bodily injury or death.
So you don't have to tackle a gunman?
No. But if you can make a 911 call safely from around the corner, you absolutely must. Failure to do so is a Class A misdemeanor.
What about for adults? Section 38.171, failure to report felony.
This applies if you witness a felony where serious bodily injury or death has resulted or might result. If you see a murder, a stabbing, a kidnapping, and a reasonable person would believe it hasn't been reported yet, you have a duty to call it in.
So if I walk past an alley and see a body, I can't just keep walking and pretend I didn't see it.
No, you have a legal obligation to alert the authorities. It effectively criminalizes the bystander effect in extreme cases. It says that as a member of society, you have a baseline obligation to the safety of others.
There are a couple of specific ones here, too. Section 38.19, failure to report death in custody.
That applies to superintendents of institutions. If someone dies in their care, they have to report it. They can't cover it up. That ensures transparency in our jails and asylums.
And Section 38.172.
Failure to report abuse in group homes. This targets those unlicensed boarding homes that sometimes pop up. If you know a resident, maybe an elderly person or someone with a disability, is being abused or neglected there, you have to report it.
It is good to know that the law demands accountability there. It closes the loop. You can't just look the other way.
Exactly.
Okay, we have unpacked the entire chapter.
Yeah.
We've gone from the traffic stop to the prison yard to the lawyer's office. This has been a massive deep dive. So let's synthesize this. If the listener takes away only 3 things from this hour, what should they be?
Summary time. Okay. Point 1, submission first, litigation later. This is the hardest one to accept, but it is the most important for your safety.
The resisting arrest part.
Yes. If you are being arrested, do not physically resist, even if the cop is wrong, even if it's illegal. Section 38.03b is crystal clear. Unlawful arrest is no defense to resisting. Fight the battle in the courtroom where you can win, not on the street where you will absolutely lose.
Point 2.
The prison wall is absolute. Do not mess with the integrity of a correctional facility. Don't bring in phones. That's a felony. Don't fly drones over it. And remember that strict liability, check your trunk before you park at a prison. Do not become an accidental felon because you forgot about a bottle of wine.
And point 3.
Respect the grief period. If you are a professional or if you're approached by one, know the 31-day rule. Ambulance chasing isn't just annoying, it's a crime called barratry. If someone calls you the day after a wreck asking to be your lawyer, hang up. They are breaking the law.
Fantastic summary. Now, before we sign off, I want to leave the listeners with something to think about. We've talked about what the law says, but let's talk about what it implies.
The provocative thought. Here's what keeps me up at night about Chapter 38. This chapter is titled Obstructing Governmental Operation.
Right.
It assumes that the government's operation is this machine that must not be stopped. We see that in the unlawful arrest clause, the machine's forward motion matters more than your immediate liberty. The law says, don't break our flow. But then, in the failure to report sections, the law flips completely. It demands you stop being a passive observer and you have to join the operation. You must report crimes. You must assist. So the question is, at what point does the governmental operation require so much protection that it overrides the individual? The law demands absolute submission in arrests, but active cooperation in tragedies. It forces the citizen to be a constantly adjusting cog in the machine of justice. It asks you to be passive one moment and a hero the next.
And knowing which role to play is the hard part.
Knowing which role to play and when is the hardest part of being a citizen.
That is a heavy thought. We are parts of the machine whether we want to be or not.
We are.
Well, on that note, thank you for taking this deep dive with us. Hopefully you never see those blue lights in the rearview mirror, but if you do, now you know the drill.
Stay safe out there.
Don't forget to subscribe, and we will catch you on the next one.